Are you an immigrant who married a United States citizen and less than 2 years later you received a grant of permanent residency on a conditional basis? Now you're required to file an application to remove those conditions. However, you have a slight problem. That application is supposed to be filed jointly with you and your spouse, but the two of you have separated. You're afraid you're going to lose a green card. Here's how the problem arises. In many marriages, when after people file their permanent residency application, their petition and the permanent residency application, it takes more than 2 years for the grant of the green card to take place. If that's the situation, then there's no problem. That often happens because there's a slight gap between the time of the date of the marriage and the date that the immigration paperwork starts. Perhaps the parties are simply procrastinating. Perhaps there's a financial problem that has to be dealt with. The fees to the government have to be paid. Or perhaps the government is simply lagging because they have so many cases and they're taking their time to process the paperwork, and 2 years pass. No problem. But in some cases, the decision is made a lot quicker by the government. This usually happens, say, in a situation where the immigrant comes in on a fiancé visa, a K-1 visa. They come in, they're supposed to get married within 90 days of the immigrant arriving. They get married quickly, turn around and file for permanent residency. The grant of permanent residency is given to the immigrant, and 2 years have not yet passed. That often occurs with couples that meet on the internet. When they meet, they fall madly in love and they want to file quickly so that the immigrant can obtain work authorization, receive a green card. And so the decision to grant the green card, the permanent residency decision, is made relatively quickly in less than 2 years after the date of marriage. But if that happens, then the couple has to file another application later because the green card grant, the permanent residency grant, will only be given on a conditional basis. It's called it's called conditions on permanent residency, and you have to file an application to remove those conditions by the second year of the grant of permanent residency. This is an anti-fraud measure imposed by the government. The government feels that most couples committing immigration sham are not going to stay married much longer after the immigrant receives the green card. Therefore, if they impose this standard, people have to come back for an interview to remove the conditions. They're no longer married. Boom, they'll be able to catch a lot more fraudulent marriages, which sets up the first requirement of what you have to do in all cases if you're filing either together or alone. You have to prove that your marriage was legitimate. You have to prove what lawyers call a bona fide marriage, that you were married in good faith, that it was a real marriage. And so there are three grounds that can be used to file a loan. These are called waivers. It's like an exception to the requirement that you have to file jointly. But in all three of them, you still have to prove that it was a valid marriage, that it was a bona fide marriage. The three grounds are: first, divorce. If you're divorced at the time you file your application to remove conditions, then and you show that it was a good faith marriage, then the government will allow you to proceed forward on your own. However, the problem often arises that there's been a separation and maybe a divorce has started, but it's not finished by the date you file. Well, the government generally has been lenient on that. They'll send out a request for evidence, which allows the immigrant time to finish the divorce process. And that's important because a lot of states impose a cooling off period for divorce. For instance, in California, if a couple files for a divorce, they can't, in most cases, get a grant of a divorce until 6 months after the date that they first filed their papers. This is called a cooling off period. The court wants to see if the couple will cool off and stay together. The second grounds for a waiver, for an exception to the joint filing requirement, is that of domestic violence. If an immigrant has been abused, been subjected to extreme cruelty, battery, mistreated, not allowed to call her family, not allowed to do anything financially, just totally under control and abused, as well as if there's physical violence, well, then the immigrant is going to be allowed to file the waiver on their own. Again, this excuses the joint filing requirement. A third reason that the government will grant a waiver of the joint filing requirement is the concept of extreme hardship. Extreme hardship to the immigrant spouse if they have to go back to their home country, if they're removed from the United States and they have to return home. The restriction on this waiver, however, is that the hardship that must be shown is the period of conditional residency, the 2 year period of conditional residency. The government wants to see that the factors of hardship were present within that 2 year period. Now, some of the factors may have originated before the 2 year period, but they had to have existed during the 2 year period. What that means is that after the conditional period is over, whatever hardship has occurred before the client's interview, before the immigrant's interview with USCIS, will not be considered by the government. So, what types of factors might the government be looking at? Well, if during the 2 year period, let's say a child was born, or a child was born slightly before to the immigrant and the U.S. citizen spouse, and that child's never been to the immigrant spouse's home country, they don't speak the language, it'd be a loss of their American privileges, well, that's a factor to consider. If the immigrant spouse has a serious medical condition, or the child that would be going with them back to the home country has a serious medical condition, and the home country doesn't really have the medical facilities or care to deal with that issue, or the immigrant spouse wouldn't have the income to obtain that type of medical assistance. What about money that the immigrant spouse sends back home? It comes from a relatively impoverished family, and so the immigrant spouse subsidizes their family by sending money home, either for food or for rent, or maybe even to help a younger sibling go to school in the area. Those are the types of considerations that would be weighed by the government as factors of extreme hardship in I-751 waiver cases. Now, one other point before we move on to what happens if the waiver is denied and the removal of conditions application is denied. And that's what happens if the U.S. citizen spouse passes away. And that's the reason that the application can't be filed jointly. Well, the immigrant spouse then must prove that the U.S. citizen spouse has passed away. And as in the other requirements for waivers, they must prove that it was a bona fide marriage. It was a good faith marriage. It was a legitimate marriage. Let's move on now to what happens if the waiver is denied and therefore the removal of conditions is not granted. Generally, the government will issue a decision giving the immigrant 30 days to leave the country. If they don't, then they'll usually be noticed that they might be referred to immigration court. They'll be referred to ICE, and ICE will then set up with immigration court a notice to appear calling the immigrant into court to face charges of deportation. During that period of time, and the immigrant must realize that they're going to have to act very fast. Within that period of time, it's possible the immigrant spouse can refile an I-751 application. It's also possible that the immigrant spouse can file a motion to reopen based on evidence that they couldn't obtain at the time they filed the application, remove conditions, but they now have it. Or there's some other facts that were missed that are now present. Or the government, in their decision, based it on wrong legal reasoning or on case law that has changed or something of similar legal effect. That's the case. A motion to reopen or motion to reconsider might overturn the original decision to disallow the waiver. If not, the immigrant could do nothing, could leave, but if they do that, if they do nothing but they fail to leave, then the danger of immigration court becomes very real. But at immigration court, the immigrant spouse can then re-raise removal of conditions. The court will allow them to file a new I-751. And also, they could raise any other defenses which may be applicable to their situation. In that situation, they would raise all those defenses to try to maintain their status here in the United States. The other thing is, certainly if there's been domestic violence cases in immigration court are often very strong because the rules are slightly different for domestic violence in immigration court than for domestic violence cases outside immigration court. In any event, if you're facing the removal of conditions without the help, without the assistance of your U.S. citizen spouse, take these waivers, 3 waivers, ponder them carefully, and see how they fit your situation. In most situations, I believe the immigrant spouse is going to need the help of legal counsel. So look for someone in your local area to assist you, at least to discuss with them before you file anything. Assess your chances of prevailing. Do not just give up. I do hope that you're able to overcome the burden and that you're able to obtain regular permanent residency status. And if you do that, then down the line, I hope that one day you take it even further and you become a U.S. citizen. With that, I'm going to sign off. I'm going to wish you the best of luck going forward. Take care. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.